Good morning, everyone. My name is Chief Justice Robinson, and seated with me at the bench are Justices Hamilton, Bick, Shine, Rodman, Gow, and Clark.
My name is Lauren Valley. Seated to my left is my co-counsel, Christy Webster. We are counsel for Patrick Jensen and Zach Green, the appellant before this court today. The following issues are before the court today. Issue 1, which is the district court erred when it concluded that Patrick Jensen did not have parental rights. Issue 2, which Christy will be arguing, is that the court erred when it concluded that Hillary Jensen will have parental rights. To address the first issue, the district court erred when it concluded that Patrick Jensen did not have parental rights for the following reasons. First, the state of Montana recognizes the rights of biological fathers. Patrick Jensen meets the child-parent relationship standard recognized by the Montana courts. And finally, to end the relationship between Patrick and his son Benjamin would be detrimental to Benjamin, both physically and emotionally. To begin with the first problem, rights of biological fathers, Montana Code annotated 40-6-105, Section F, accepts the scientific evidence resulting from a blood test as proof of paternity. The test was a home paternity test, but both Patrick and Zach, the primary caregivers to Benjamin, agreed to take the test and were both accepting of the results. Patrick, even before he took the test, helped raise Ben, and
Excuse me, counsel. So just because we're accepting that Patrick Jensen is the biological father of Zach Green, does that necessarily warrant that he is the legal father?
Technically, just biological relations does not mean that he deserves parental rights, but because he has established a biological relationship and a child-parent relationship, I believe that he should.
What do you mean by established biological relationship?
Well, the home paternity test establishes the biological, that they are related biologically.
Okay, all right, thank you.
In re-paternity of Adam, it states that the significance of the biological connection is that it offers the natural father an opportunity that no other male possesses to develop a relationship with his offspring. If he grasps that opportunity and accepts some measure of responsibility for the child's future, he may enjoy the blessings of the parent-child relationship and make uniquely valuable contributions to the child's development. Patrick Green has grasped the opportunity by taking care of his financial needs and his physical needs, and by providing food and clothing and other money for Benjamin.
Counselor, in paternity of Adam, we established that it's a two-part test to establish those rights in the biological father. First, they have to establish that they are, in fact, the biological father, and second, they have to look to the best interests of the child. Could you walk me through why it's in the child's best interest for Patrick to be also a father?
I think it'd be in the child's best interest for Patrick to be a father because he has also acted as a father figure towards Benjamin throughout his entire life. He has set up a schedule with Zach and Zach's mother to have equal time with their child and to take care of him. He's supported him financially, and I think, he has provided physical care as well. And I think for that, he would be at a loss without Patrick as a father.
So in paternity of Adam, we established that we have to look to the existence of its current home environment, the current home environment of Ben, and that's a positive environment, correct? You would say that. It's also a stable environment as it exists right now.
Yes.
Is there any uncertainty about the child's parentage in the child's mind?
I think the uncertainty lies with Hillary, as he recognizes her but does not recognize her necessarily as his mother because he calls Zach Green's mom. And he also calls Zach daddy, but he calls Patrick friend daddy and Patrick daddy, which I think proves, if anything, that he recognizes Patrick as a father figure. So technically that might be confusion, but I think because he's established that relationship that he deserves the right to be called.
Excuse me, counselor. So under what Montana law specifically do the reasons you lay out make Patrick Jensen the legal father?
I think that Montana Code Annotated Section 40-4-211, subsection 6, I will read that to you. It says that the party seeking to establish this relationship first must demonstrate that they provided for the physical needs of the child by supplying food, shelter, and clothing, and that the party further must demonstrate that she provided the child with necessary care, education, and discipline on a day-to-day basis through interaction, companionship, interplay, and mutuality that fulfills the child's psychological needs for a parent as well as the child's physical needs. In the factual background, it states that Patrick arranged a schedule to care for the child and agreed to help Zach financially and spend time with him. He also provided primarily for Ben money to pay for food, clothing, shelter, and actual physical care. And for that reason, I think that he has provided the care and therefore deserves the right and has proven the right to meet the child-parent relationship.
Counselor, before you proceed, I want to clarify what exactly your client is seeking here. Are they seeking a adoption or just establishment of parental interest under Section 228?
Just establishing the parental interest. He
Okay.
wants parental rights, but not necessarily custody or anything. So even before discovering his biological relation to Ben, Patrick was still willing to provide for him and therefore had established a child-parent relationship. Finally, sorry about that. Finally, to end the relationship between Patrick and Benjamin would be detrimental to Benjamin. Not only did Patrick provide all of these things as far as financial support, physical support, etc., he has established on a day-to-day basis that he cares for Benjamin. Benjamin has known him his whole life as a father figure, and therefore he is attached emotionally and physically, needs day-to-day care, which he is given.
Excuse me, counselor. So how does not giving Patrick the parental rights to Benjamin Green end their relationship? Just because they're not parents, just because Patrick is not the parent to Benjamin right now doesn't mean that they don't have a relationship?
Well, technically, they could have a relationship. They just wouldn't have necessarily the relationship they do now, as far as he could not act as much as a father figure as far as he is providing money. And he does care about Benjamin and wants those rights, and I think that he has proven because of that and because of his care towards Benjamin that he deserves them.
Right, okay. Right.
And because he has established that he is a biological father, and that even without the biological relation that has established a child-parent relationship and their emotional and physical bond, I believe that the court erred when they decided that Patrick Jensen did not have parental rights. And I yield the time.
Counselor, before you leave, one more question for you. I'm a little surprised that Zach acquiesced in doing this DNA test to determine the paternity, the biological paternity of the child. Because I understand it that Zach only has a presumption of paternity as of today. And with the DNA test, that presumption is successfully rebutted. What is Zach's interest in the child going forward now that the DNA proves that he's not the father?
I think that Zach is still very interested in raising Ben just as he had before, except with the help of Patrick and his mother.
At this point, then, can Hillary petition to take away Zach's parental interest in the child?
I suppose she could, but I don't think that would also either be in the best interest of the child.
Okay.
I yield the rest of my time to my...
May it please the court, my name is Christy Webster, and I will be addressing the second issue, that the district court erred when it denied Zach Green's petition to terminate Hillary Wilson's parental rights to Benjamin Green for the following reasons. Hillary did not establish a parent-child relationship according to Montana state precedent. Due to her long-term neglect, she has abdicated her rights as the biological parent, and it is not in the best interest of the child for Hillary to continue to have parental rights. To address my first point, in her absence, she has not established a parent-child relationship. Benjamin has no clear memories as Hillary as a mother, and, in the court law in Colstead 2009 defines a parent-child relationship as the parent has provided for the physical needs of the child by supplying food, shelter, and clothing, provide the child with necessary care, education, and discipline on a day-to-day basis through interaction, companionship, interplay, and mutuality to fulfill the child's psychological needs for a parent as well as the child's physical needs.
Counselor, Colstead stands for the proposition that we can grant a third-party parental interest, but it doesn't necessarily say that we can take away a parental interest. What authority are you relying on to take away Hillary's parental interest?
The law for that one?
Sorry, which statute, what case law?
The case law I have laid out is the JM versus RH case law, and I can pull that up for you. That JM's parental rights were terminated for 8 reasons. Excuse me, let me find the paper. And according to reason number 5, that neither minor child has a significant relationship with JM, as Hillary does not have a significant relationship with Benjamin.
Excuse me, counsel, what would you determine as significant relationship then?
As defined in Colstead, providing for the physical needs and emotional relationship where he recognizes the parent as a parental figure and not as a woman who just sends gifts, I believe would be a significant relationship.
Just to be clear, Counselor, you're saying that there's no parent-child relationship and therefore her parental rights should be terminated? You're not asserting that she abandoned the child?
No, not currently, that she has not met the standards for a parent-child relationship, and according to the law that she cannot, she not have parental rights according to the case laws. And, but she has asserted neglect, I believe, which in accordance to the Montana Code 42-4-608 is one of the standards that is one of the or statements that if it is met, that can, the termination of a parent-child, the parent.
Doesn't the neglect in that statute have to refer to neglecting the child's well-being, not leaving the child's father to start a different life? That's not the same definition.
Yes. To address the 608 code, it says that the respondent is not able or willing to promptly establish and maintain contact with the child, which is under the terms for neglect. And I do not believe that Hillary has maintained contact with the child, as she has infrequently called and infrequently sent money that does not constitute for child support, and she has not shown that she's willing to promptly establish the relationship. As in the previous year before this case was brought up, she only called 5 times in the whole year.
Counselor,
Yes.
I'd like to refer you to the introductory language to 42-2608. It says that a court may terminate parental rights for the purposes of making a child available for adoption. But as your co-counsel stated, this is not an adoption case. Nobody has filed for adoption. So why is this statute authority for terminating her rights?
It is for the unfitness of the parent, I believe, and to show the unfitness of a parent that does constitute for the termination of the parent-child relationship, as it is shown in the court case of the JM versus RH.
So JM versus RH also relied on 42-2608 because that was an adoption case. Would you agree that if this is not an adoption case, JM is not controlling?
I believe that it is relevant to the circumstances of the case, even though this is not an adoption. Hillary has not been around for her child, and so they're very similar parts of the cases, so I believe that they are related.
Furthermore, it says in that statute that a person who is deemed unfit if they abandoned or neglected their child, and you're saying that she hasn't neglected or abandoned her child. This is not a case about abandonment, so how does this law?
I am saying she has neglected her child and has abdicated her rights as the parent of the child.
Do you have a definition of neglect then?
Neglect would be abandoning or not abandoning, but leaving the child for long periods of time, neglecting to maintain contact with the child, and create a physical presence for the child.
And so
Excuse
why
me,
should the
counsel.
court, oh, sorry, go ahead.
According to the in readoption of BWZ-S, aren't we supposed to take into consideration the totality of the circumstances rather than just little bits of what Hillary may have done?
Yes, and I believe in the totality of the circumstances. For her 4 years, she has shown sporadic contact with the child. She has shown inconsistency in wanting to showing that she may return. She has shown inconsistency in sending money, which I'm sorry, I'm out of time. Thank you, counsel.
May it please the court, my name is Emily Lenore. Seated to my right is my co-counsel, Leah Hohenmo. We are counsel for Hillary Wilson, the appellee before this court today. I will be arguing issue 1. The district court did not err when it concluded that Patrick Jensen did not have parental rights to Benjamin Green. Benjamin is not legally the child of Patrick by blood. According to Montana Code Annotated 40-6-105, presumption of paternity, a person is presumed to be the natural father of a child if the scientific evidence resulting from a blood test, whether ordered by a court or administrative agency of competent jurisdiction or agreed to by both parties, shows a 95% statistical probability of paternity. The paternity test that Patrick took was not a blood test, nor was it ordered by a court or administrative agency. It was not agreed to by both parties. Zach and Patrick did both agree to take the paternity test, but Hillary had no such knowledge. Now, although Zach and Patrick did agree on the result of the at-home paternity test, without a scientific resulting test, we cannot be sure of the natural father. It is not in Benjamin's best interest to have Patrick be his father. Biology is a weighty factor in determining paternity. For all intents and purposes, Zach is the biological father and looked upon as such. For instance, the birth certificate of Benjamin Green states Zach Green as the biological father. Hillary and Zach were married as soon as Hillary found out about her pregnancy, and being married is one of the qualifications of paternity. Benjamin views Zach as the father figure. By calling Patrick Daddy or friend Daddy, and Zach being called just Daddy, the simple choice of words shows that Benjamin sees Zach as his primary father figure. Therefore, it is not in the best interest of the child. Patrick and Benjamin's relationship is completely different and inferior to Zach and Benjamin's. The choice of words and the primary care and home for Benjamin shows that. Zach uses his home to care for Benjamin as well as his mother to help alongside him. Patrick does provide care and money, but nothing further, while Zach offers up his home and primary care for Benjamin, as well as health insurance for the child. The statement of the facts says that Zach provided the following for Ben: money to pay for food, clothes, shelter, and health care. Through the care, we can see that Zach went above and beyond his expectations to take care of Benjamin, while Patrick did not do as much as Zach.
Counselor, why are we judging Patrick's contributions towards the upbringing of this child against Zach? Is that required by statute or case law? Can't we just say that he's contributed financially in significant ways to the upbringing of the child, and that's enough?
He has, but so has, for instance, Zach's mother, and Zach's mother should not be granted parental rights.
And furthermore, you're saying that we can't give Patrick the parental rights just because Benjamin calls him Patrick Daddy instead of just Daddy. Has he called his biological mother or mom in that same way?
I do not have the evidence to show what he calls his mother. However, we are showing that Patrick provides for the child, and Benjamin does call Patrick by Patrick Daddy, but he sees Zach as his primary father figure.
Okay.
Patrick.
Counselor, one more thing before you move on. Are Hillary's interests affected in any way by awarding a parental interest to Patrick in this case?
I would not believe so.
Okay, so if her interests are not affected, why is she one of the two parties that you referenced earlier? It seems to me that Zach's interests are at the greatest risk of being wiped away here. So wouldn't his consent to the DNA test be sufficient for purposes of the statute?
I believe it would, but Hillary is seen as the biological mother, so I would think that she should have a say as to the at-home paternity test as well. Patrick did not provide clear and convincing evidence that he established a parent-child relationship with Benjamin. In Kolstad v. Maniaci, Kolstad is said to have provided clear and convincing evidence of a child-parent relationship because she lived with the children and functioned as a parent to the children on a day-to-day basis. Additionally, she provided for the children's physical, psychological, and developmental needs. Clear and convincing evidence is a remarkably high evidentiary standard and one that Patrick has by no means met. Benjamin did not live with Patrick primarily. Zach continuously cared for Ben along with his mother. Patrick may have...
Excuse me, counsel, didn't Patrick's case differ from Kolstad because he did have a biological tie to Benjamin?
Yes, but we are looking at Kolstad versus Maniaci to reference the clear and convincing evidence of the relationship. Patrick may have looked after Benjamin but did not fulfill the role of a parent, while Patrick looked out for him, but it was no more than how a grandparent would. I now yield the remaining of my time to my co-counsel.
May it please the court, my name is Leah Hohenlohe, attorney for Hillary Wilson, co-counsel to Emily Lenore on the appellee side of today's case. I will be discussing Issue 2. The district court did not err when it denied Zach Green's petition to terminate Hillary Wilson's parental rights to Benjamin Green. However, first I would like to clarify one issue brought up in Issue 1 as discussed by my co-counsel Emily Lenore. The reason that we are using Zach's care for the child and comparing it to Patrick's care for the child is to establish what the different relationships that Benjamin has with the men mean. Zach has contributed more. Patrick has contributed the same amount that a family friend or a grandmother has contributed. We can see that Zach's mother...
Excuse me, counsel. So how does Hillary's contributions compare to both Patrick and Zach's then?
Hillary has been a way to clear her head, but she has contributed monetarily and has spoken to her child over the phone during the period of her absence.
So how does the financial support and the contact that Hillary's provided compared to Patrick's? Has it been more or less?
I would say as she has been away, she is incapable of giving as much. However, one clear difference we have to see between Patrick's case and Hillary's case is that Hillary is actually proven in a court of law to be the biological mother of Benjamin Green.
So, yeah, so has Patrick Jensen, though.
As my co-counsel Emily Lenore addressed, the at-home paternity test that Patrick took can't stand in a court of law as it wasn't agreed to by both parties. It wasn't stated in the statement of facts to be a blood test, and so it can't hold scientifically in a court of law. So for all intents and purposes, we are viewing Zach Green as the biological father to Benjamin Green as stated on the birth certificate.
But you would agree, though, that Patrick Jensen is the actual biological father, even though in court he is not recognized to be that, right?
No, I wouldn't recognize him as such until there is evidence that he can be recognized as such in a court of law.
Okay.
If Zach has already acknowledged that he's not the biological father by accepting the results of the DNA test, aren't we already at a position where we have to accept that Patrick is?
What Zach says can only go so far. At the end of the day, there needs to be substantial scientific evidence that Patrick is indeed the biological father of Benjamin. Until we have that evidence, we can't consider Patrick to be the biological father.
Are you saying that most of what everybody brings up in the case should not be taken to a certain extent?
I'm saying that yes, biology is not on Patrick's side because there hasn't been an established scientific biological connection between Patrick and Benjamin. I would now like to move on to Issue 2. The district court did not err when it denied Zach Green's petition to terminate Hillary Wilson's parental rights to Benjamin Green. First, I would like to look at the fact that it is not in the best interests of Benjamin to terminate Hillary's rights. In order for comparison, I'm going to be comparing this to a case, JM v. RH in Ray JWM, in which the parental rights of the paternal father or the biological father were actually terminating, and explaining how this case differs from that case, and so therefore it is in fact in the best interests of Benjamin to have Hillary have parental rights. The reasoning for JM's termination of parental rights in JM v. RH in Ray JWM was, the court says it is because of the history of drug and alcohol addiction, lengthy absences from his children's lives, and his failure to consistently financially support his children, termination of JM's rights was in the best interests of the child. Now I'm going to be breaking down the reasoning. First was the history of drug and alcohol addiction, which Wilson has shown no sign of.
Excuse me, counsel, doesn't the statement of facts say that she came home smelling of marijuana and such?
Well, the fact that she came home smelling of marijuana is not condemning evidence that she was actually under the influence of marijuana
So
at
then
any.
how else would you link a person smelling of marijuana? How would she have smelled of marijuana? Was she like putting on marijuana smelling perfume?
No, that's not what I'm saying in the slightest. I am saying that smells can stick to clothes. For example, if you walk past the areas in airports where people smoke cigarettes, often smell of cigarette smoke, and if someone were to hypothetically enter a cigarette smoking room, and the smell would linger on their clothes.
So you're saying then that Hillary went to an area that was full of marijuana smoking people then?
I'm saying that she could have been near someone who was smoking marijuana. The fact that she smelled of marijuana is not condemning evidence that she did in fact smoke marijuana. It just means that she smelled of marijuana, nothing more.
Then how would you explain her behavior walking past someone smelling of marijuana then? If she would just walk by someone, that doesn't necessarily mean that the smell of marijuana would stick to her.
So the fact that she went to bars, which is perfectly legal, for an adult over the age of 21, there could have been people around the bars who were smoking marijuana. I am simply just saying that the fact that she smelled of marijuana does not mean that she was ever under the influence of marijuana.
Just to clarify, the case you're talking about, the father admitted to having these drug problems, and here Hillary has not admitted to having any sort of drug problem, correct?
Correct. Hillary hasn't admitted to drug problems. She hasn't admitted to alcoholism. It's completely different from JM's admission of having those substance abuse issues. Next, we must look at the lengthy absences from his children's lives in JM v. RH's case. We can see that during his absence, he didn't make any effort to contact his children, whereas Hillary clearly has. She called her child on the phone on multiple occasions and never went more than 6 months without contacting her child. So even though she was not physically in the presence of her child, she still maintained a connection, and the absence was not the same as it was in the JM v. RH in Ray JWM case.
Excuse me, counsel, so given your logic, and given that Patrick Jensen has made more of an effort to have contact with the child, whereas Hillary has only made hers once every 6 months, how would you argue then that Hillary should be the parent and not Patrick?
So, as I have stated previously, Hillary already has a clear biological connection to the child, which Patrick has not shown. And so Hillary's standard for proving that she has a parent-child relationship would be less than Patrick's.
So you're saying then that just because she's biologically the parent means that she should have, even though she has treated Ben less of a child, has cared for Ben less than Patrick has, she should still be the parent?
I'm saying that in order for someone who is not legally the biological parent of someone to have established parental rights, it's a very different standard from having parental rights terminated of a biological parent. We cannot give people parental rights with impunity that play the same role as a grandparent or a family friend. Hillary is already the biological mother of Benjamin Green. Benjamin has certain rights to know his biological mother, and Hillary has certain rights to establish a relationship and maintain a relationship with her biological child, something that Patrick does not have because it cannot be proven at this time with the evidence presented that Patrick is indeed Benjamin's father, Benjamin's father.
Thank you.
I'm going to move on to the final reason in JM v. RH that JM's parental rights were terminated, and that he failed to consistently financially support his children. Now, in this case, Hillary does indeed send money over the course of her absence, and she does this not because a court has mandated that she must, but simply because she feels obligated to. So no court has mandated that what she has sent is not enough. What she is sending is above what she would have to do since there is no court mandate saying how much money she has to send, the amount that she has sent is actually more than she would necessarily have to maintain her parental rights.
Counselor, are you saying that she could get away with sending nothing and still maintain her parental rights?
I'm not saying that necessarily. I do think it's incredibly important that she sent money to the child because that shows that the child's best interests are at heart. I was simply going off of a hypothetical, but I don't believe that she could have gotten by sending absolutely nothing to the child. I'd like to move on to another point, the biological connection to the parent, and I touched on this briefly before, but children, I believe, have a right to know their biological parents and to establish a relationship with them. And I believe that biological parents have a right to establish and maintain a relationship with their biological child. So we can see
Excuse me, counsel. Is biology everything in this, or is it just a factor that plays into a multitude of other factors?
Biology is just a factor that plays into a multitude of other factors, but it is an incredibly weighty factor. And as we can see that Hillary was caring for the child while she was away and maintaining a relationship with the child while she was away via phone calls and sending money and gifts, that biology is just another factor that shows why Hillary Wilson should have parental rights to her child.
Excuse me, Counselor. So just because because Benjamin should know who his mother is, does that mean that that every decision made by the mother will be right for Benjamin?
Do I have permission to answer the question, though my time has elapsed?
Yes.
Okay. I'm sorry, could you please restate that?
So just because Benjamin should know who his mother is, does that mean that everything Hillary does for Benjamin is in the right interests for Benjamin?
I think, as I stated previously, biology is only one of the factors that we need to consider, but given that I have stated other reasons, other factors that play into this that fall to Hillary's side, biology is just the final factor that proves that she should have parental rights to her child. Thank you.
Counselor, before you step away, could you clarify for me, there appears to be some evidence that regarding interference with parental rights in the record here. How does that play in? Is that a significant factor in this case?
I'm sorry, interference in...
Interference with the exercise of her parental rights by the mother. Has the father restricted access to the child in ways that would make it difficult for the mother to maintain contact?
Yes, definitely. During the divorce of Zach and Hillary, Hillary was given no visitation rights to the child. So during a period of her absence, the calls that she made was the best that she could do at the time because she didn't even have visitation rights to her child. Thank you.
Thank you.
May it please the court, my name is Christy Webster, and I will be doing the rebuttal. To clarify on issue 1 on the appellant's points, that Patrick Jensen meets the child-parent relationship standard recognized by the Montana courts. According to Montana Code 40-4-211, he has provided food, shelter, and clothing to Benjamin. He has provided the necessary care, education, and discipline on a day-to-day basis that fulfill the psychological and physical needs of the child. Patrick and Zach's mother have agreed to a schedule to contribute equally to Benjamin's care. Though the DNA test was not court-ordered, but it was agreed to by Zach and Patrick, which we believe are both parties, seeing as they are the ones who want to determine the biological parent of Benjamin. And because Hillary was not there and she was the one who incited the doubt in the mind of who the biological parent was in telling Zach that, why should you care? He's not your child anyway. That incites the need to discover the biological parent, and so both parties would be Zach and Patrick, as they are both the fathers who need to decide. And seeing as they are both Benjamin's primary caregivers, it makes it more relevant. Even though the test was done at home, it was based on biological evidence, proving that there is a genetic relationship between Patrick and Benjamin. To address the fact that Benjamin refers to Patrick as Patrick Daddy or Friend Daddy, this is simply a way for the child, who is about 4 years old, to distinguish between his two parental figures. They are both fathers to Benjamin, as he calls Zach, dad, and Patrick, daddy. This shows they are both parental figures to him. To address the second point, that Hillary's parental rights should be terminated, first, I would like to state that Patrick has meant more to the family than a family friend, but Hillary has acted more as a family friend than a parent, as she has sent occasional gifts, which include money, and does not constitute for regular child support.
Excuse me, counsel. Given that Patrick has not been proven to have the genetic and paternal relationship within the purview of this court as set forth in MCA 40-6-105, shouldn't slightly different standards be applied to Patrick and Hillary, given that it has been proven that Hillary has a purely genetic relationship with the child?
I believe in this matter the genetic relationship is not pertinent, as in the re-paternity of Adam, the Montana Supreme Court held that the mere existence of a biological link does not merit the equivalent of constitutional protection, and to follow that with the Montana Code annotated 40-4-227 Section B, that a parent's constitutionally protected interest in the parental control of a child should yield to the best interest of the child when the parent's conduct is contrary to child-parent relationship. Hillary has shown that her relationship with Benjamin is contrary to a child-parent relationship and more as a family friend, or not even, because Benjamin does not recognize her very well and only recognizes her as the woman who occasionally sends gifts and occasionally gives short FaceTime calls. This does not constitute as a parent relationship, I believe.
Counselor, I'd like to refer you to adoption of BWZ-S. That involved a parent who was arguably derelict in his duties as a parent, and yet we still found that it was improper to terminate his relationship. Can you tell me why this case is different than BWZ?
This case is different because that Hillary has neglected her child for over 3.5 years.
Well, in BWZ, it was more than 4 years, potentially 5 years, and yet we still preserved that right.
Yes. According to, I'm sorry, I cannot give you a clear answer with the time remaining on this, but I would like to state that Hillary differs because she has moved away and not shown contact or interest in growing a child-parent relationship, and she has not met the precedent of a parent-child relationship set shown in Colstead, where you provide for the child on a day-to-day basis. And in the most recent year, she only called the child 5 times and sent a total of $36. And I don't think that constitutes as a parent-child relationship, even in the form of a support. These are gifts. These are not a parent showing parental responsibilities of Hillary to Benjamin.
Counselor, how much money would she need to provide in order to protect her parental interest?
Enough to meet the financial needs of the family.
What if she can't do that?
Yes, as seeing as Zach and Patrick both work to support Benjamin, Hillary's money is obviously not enough to substantially help them, seeing as they both have to work to provide for Benjamin. Thank you.
Thank you, counsel. We will take the matter under advisement. This hearing is adjourned.
Well, I think you guys did really well. I think that all of you did very well in the oral arguments, and particularly when you were being peppered with questions by us. I know personally how difficult it is to keep your train of thought when you have like a prepared speech and then people continually ask questions. So I just want to say congratulations to all of you guys, and congratulations just for showing up. You know, it's hard. You take time out of your social lives and your school and all that other stuff, and you guys have really proven that you guys deserve to be here. So congratulations.
I'm really impressed with how well you handled a very complicated case, actually. In order to make a credible argument on the first point, you have to argue against yourself in a way on the second point, to say that the biological interest of Patrick is somehow inferior to the biological interest of Hillary, or vice versa. So I thought you've done a fantastic job of walking that tight line. I would offer a few just points. In this scenario, when you're in front of an appellate court, it's not great to try to dispute the facts. So when we get off on a long discussion of what it means to be smelling like marijuana, isn't necessarily beneficial. It's better just to say that the district court determined the facts, you have those before you, take them for what they will, but regardless of whether or not she smelled like pot, that doesn't necessarily mean she should lose her parental rights. But I also thought that it was a great pickup of Hillary's remarks shouting that you're not the father anyway as evidence that she in effect gave consent to the fact that Zach wasn't actually the biological father, and it needs to be proven through a paternity test. So I thought that was a very nice pickup and an otherwise very difficult argument to make.
I agree that you all did a terrific job, and your poise and presence and ability to argue under pressure was fantastic. Each of you is very coherent, very clear in your arguments, very well prepared, and I think provided really very credible, very meaty arguments for your clients, and did a great job. Thanks for devoting the time that you did in preparing for this, and I congratulate you on doing really fine.